And we will move right to People versus Davis. Ms. Smith, I welcome you back to the podium.
Thank you. It's a busy day for the Wayne County Prosecutor's Office. Good morning, Amanda Smith, Wayne County Prosecutor's Office. On behalf of the people of the state of Michigan, I'd like to reserve the balance of any time I may have this morning with the court today. This is People versus Joel Davis, a published opinion coming out of the Michigan Court of Appeals. And this case really, I think, was a game changer, and that's why I filed the application, and I'm glad the court took it and did me the honor of doing a full grant for my first time here. I have a lot of issues with the lower court opinion. I want to focus more on this court's questions 3 and 4, which we didn't really touch on in the prior argument. Though what I said for Price, my view of the statutes for 750-84 and 81A, that holds true. The Court of Appeals in this case disregarded the second issue presented by a defendant on appeal, and that was double jeopardy. The court indicated that that was not the proper focus and stated that the question presented by defendant was more nuanced than articulated. The court then reviewed the jurisprudence in the state of inconsistent jury verdicts and agreed, well, this case doesn't really fit with that analysis either. What kind of shoe does it fit in, I guess, is what the court was looking for. So they looked to the Georgia Supreme Court and adopted the rule from that state on mutually irreconcilable or mutually exclusive verdicts. Though the Davis panel then went on to acknowledge that the facts of this case really don't fit with the ambit of that rule because the jury was not told to, nor did they make irreconcilable factual findings. And that is what the mutually exclusive rule is all about. Nonetheless, the Davis court went on to make 2 findings. One, the error in this case was the people charging these 2 crimes together as a pair. I believe the court expected us to elect between counts. And second, the court indicated that the trial court judge should not have entered judgment on both convictions because of this facial inconsistency in the statute. There was no case law cited for that proposition. It was just the rule handed down by Davis. And so that's where we are today with this rule that I think the court tried to adopt, but then also recognized that it didn't exactly fit. I spent a lot of time in Section 3 in my brief going through how other jurisdictions treat that rule. It is a minority rule, as the Tennessee Supreme Court pointed out. In that state, similar to Michigan, Tennessee does not recognize or warrant or give relief to inconsistent jury verdicts. Due to that fact, the Tennessee Supreme Court decided to not grant relief in the event that a defendant had an inconsistent or mutually inconsistent verdict issue. And I urge this court to follow that same type of reasoning. But I also, really wish that the court would acknowledge that this mutually exclusive verdict rule is a solution to a problem that doesn't exist because it just simply doesn't fit the facts of this case. As I said, the jury did not make irreconcilable factual findings, and because there are multiple acts committed by the defendant in this case, it does not fit within the ambit of that jurisprudence. And I'm not sure if I said this before, but I would stand for questions at any time. I don't know if I have 5 full minutes. That's a long time to talk uninterrupted.
I assume your argument about the double jeopardy claim is the same as it was in the last case. Is that
That's true, because I still have Paren 3, which I'm really holding my hat on. I went on Blockberger. I don't know that any Court of Appeals panel has said differently, and I know that in defense brief, they don't get to Blockberger because they know they can't win. They're cognate offenses. They're different offenses. Different elements are required for each. Under Blockberger, this court adopted that in Ream. The people win on that point. So really, you have to try to get to that threshold inquiry, which was Justice Markman's question, and I'm hanging my hat on Paren 3 of 84.
So they can't win on Blockberger, so what? They win on some other ground. Isn't that what they're saying?
Right. I don't know that the focus so much for defendant's argument is double jeopardy. I think it's the idea of the mutually inconsistent statutes, or question 2 posed by this court. It's double jeopardy by another name, frankly, because it's not grounded in the Fifth Amendment. It's just something we're doing for the first time, kind of. I don't know. There's not a lot for me to work with on that point. As far as Michigan law, I couldn't really find any cases to support that proposition.
If there are no further questions, you can reserve some time for.
I will. Thank
Yeah.
you, Your Honor.
Should have said at the start, you each have 20 minutes on this because it is a full grant. I know you knew that. I apologize for not saying that up front.
Good morning, Your Honors. May it please the Court, Jacqueline McCann on behalf of Joel Davis. I do want to make a few points in my free fire zone. First, in response to the idea that these were separate assaults, this was referred to repeatedly in closing argument and in the testimony as a single beating, a single attack, and they used the course of this continuous conduct to argue that showed the intent to commit great bodily harm. So this was not a situation where these were presented or could be presented as separate acts. The unit of prosecution was the beating or the attack. Had we raised a specific unanimity instruction issue, we would have lost because of that. So moving on from that, I think the broader question before the Court, that it's important that the Court recall under what context the legal landscape at the time that People versus Doss was decided. It was pre-Cornell, it was pre-Ream, pre-Nutt. So at the time, they wouldn't have had to rely on the mutually exclusive verdict type issue because these would have been presented as a greater offense and an alternative lesser offense clearly to the jury as, you know, one possible verdict, not two. It would have been under Ora Jones, it would have been a cognate lesser, and that would have been made clear to the jury. Under the double jeopardy jurisprudence of the time, had the jury somehow been confused and still checked the guilty box on both of the counts, the Court would have set the lesser offense aside under the prevailing double jeopardy case law at the time. So the Court, when it decided Doss, never had to look at this sort of mutually exclusive question because the other case law of the time would never have allowed this problem to occur. So because that other case law has changed, Doss sort of presents this wrinkle that the Court should now address. And I would open myself up to questions at any time as well. I will say that...
Counsel, can I ask you, please?
Sure.
This Court has explained in a number of its decisions that we see, and I'm quoting, the principal thrust of double jeopardy protection by the very terms of our federal and state constitutional provisions is protection from repeated prosecutions for the same criminal offense arising out of the same conduct. And the provision in issue here, 750.843, uses that precise language, arising out of the same conduct. Would you agree that the statutory language arising out of the same conduct does connotate some reference to double jeopardy law? And if so, can I ask your view as to why the legislature would have used such language arising out of the same conduct, if not largely to defeat a double jeopardy argument?
Well, my answers to that would largely mirror Mr. Baker's, but I did want to point out, consistent with Justice Kavanaugh's question, that 81A was passed at the same time as that this subsection 3 was added to 84, and yet they include the language in 81A that the person not have the intent to commit great bodily harm less than murder. I think they can be read and need to be read in harmony. There are a multitude of offense statutes in Michigan that do not contain the language that 81A has that would prohibit a conviction of GBH at the same time. So the legislature chose to keep that in 81A, or actually to enact that in 81A. So clearly they mean it to be read in harmony with the subsection 3 and 84.
So whenever there's a statute that uses that language, as we have in this case, we look at the other statute that's putatively in conflict, and we resolve the issue on the basis of that other statute exclusively, and don't even get to the stage of the analysis where we look to Blockberger.
Yes.
That's an interesting double jeopardy analysis, is it not?
Double jeopardy analysis in Michigan, the first stage is to look at legislative intent. And where they have said in a statute, the mens rea cannot be great bodily harm less than murder, then it cannot be also also convicted of great bodily harm less than murder. It's very specific language, and the court can't render it nugatory.
Unless the first statute is designed, in effect, to respond to that conflict.
Well, they
And
were
say,
designed at the same time.
notwithstanding that conflict, there is no double jeopardy claim available.
They were designed at the same time, and I think the court can read them in harmony and that they don't conflict.
And we
For
don't-
instance, CCW and felony firearm. I believe it's the felony firearm statute that says you can't apply this to CCW. I don't believe that the CCW statute says, references the other one as well. So you still have to read them both, and you still have to give effect to them both. And you have to do the same here. It's just that in 81A it says you can't also have this greater mens rea of great bodily harm less than murder.
But again, despite the language in subsection 3, we end up looking exclusively at the other statute, and we don't get to the traditional double jeopardy test of Blockberger.
Well, you don't exclusively look at the other language. You read subsection 3, but then you look to the other statute. And so subsection 3 is the general rule. And then when you look at 81A, it has a specific exception to that general rule that you have to read.
Thank you.
And so, yes, we don't get to Blockberger. There are a few modern references to the exclusive verdict concept, mutually exclusive verdict concept, even though it hasn't come up in our jurisprudence because of the way the double jeopardy and the lesser included offense law developed. But in addition to the case of Smith, which I think Ms. Smith acknowledged from the 70s, Justice Zara, you had a case in the Michigan Court of Appeals, People versus Long, 246 Mich. App, I think 582 in 01, that referenced that Smith case and referenced this concept of the mutually exclusive verdict for, at least in the, for attempted murder and AWIM. So it's not that Michigan has never thought of it, it's just that we haven't needed it until modern, Cornell and modern double jeopardy. So we would ask the court to correct that wrinkle in the law that now exists of DOS, because DOS, without the old case law for, pre-Cornell and the double jeopardy, without that, it does create this wrinkle, and this court needs to address it. It's really, I have this in my brief, I think it's really unfair to jurors, because jurors would not do this if they were told what the difference was, most likely. It's sort of the opposite of jury nullification. So I would ask the court to address it.
Thank you, counsel.
Good morning again. So to reply to a couple quick points by sister counsel, when I talked about the multiple acts in this case for Mr. Davis, I'm really not indicating what the prosecutor argued in her closing argument. My point is that the mutual exclusive verdict rule has a very specific and narrow application, and the Georgia Supreme Court expounded upon that definition in 2007, Waits versus State. The rule against mutually exclusive verdicts applies only when the conviction results from the same act involving the same victim at the same instant, where the victim suffers several injuries. Conviction for both intentional and negligent crimes are not mutually exclusive. So in that case, that was the crime pair that they were analyzing. So I focus at the end of my brief on the assaultive acts committed by Mr. Davis against the victim in this case, because it does not fit within the ambit of the mutually exclusive verdict rule. The cases that do talk about that rule talk about a single act. So one financial transaction, was that embezzlement, was a larceny? A single killing, can you have manslaughter and murder together? I think there was a case out of the 1800s in Massachusetts Supreme Court over a stolen sheep, one sheep. So that's what we're talking about. We're not talking about multiple assaults causing multiple injuries to a victim over a short period of time, but yet a period of time, not one instant. This is just not the case to bring this rule to Michigan. This court has said in the Ann Arbor gun case from last summer, Justice McCormick, and I believe the concurrence by Justice Clement, you don't lose anything. You're not prejudiced by not taking an issue when the issue has not been properly presented by the parties. Again, in this case, Joel Davis, the issue for the Court of Appeals was double jeopardy. The parties were not given the opportunity to respond to this mutually exclusive verdict rule that the court came up with. I was there at oral argument, I was not endorsed, and I sat on my hands and just watched the ship go down, basically thinking, this is gonna be a lot of work for me, and it has been. But the people were denied a full and fair opportunity to present our arguments to the Court of Appeals as to why that rule does not fit within this case. I can understand facially why we got to this point, because when you read the statutes together, they appear to conflict. But I still think DOS is good law, and the Court of Appeals did not ask or say anything negative about DOS. They acknowledged DOS is indicating that negative intent language is not an element that people have to prove. It's not a negative element. In treating it as if the negative intent, without the intent to do great bodily harm, is somehow meaning that a person acts without the intent to do great bodily harm, that's not how that was understood in DOS. And I thought it was really enlightening to read the Court of Appeals opinion in DOS, followed by this court's opinion in DOS. Because the question for the Court of Appeals was whether that defendant's intentional actions could then sustain a charge of manslaughter, which says in the statute he acted without malice. Well, if he had intentional actions, then clearly he did not act without malice. This court was very clear in DOS, and you cited to a case 3 years prior, Chambliss. Elements are by their definition positive. A negative element is a contradiction in terms. So this language, this negative intent language, I'm not saying it's negatory. It has meaning. That's been a big concern by the Court of Appeals, that if we don't give positive effect to that language, somehow we render it moot, negatory, without effect. It has meaning. It just does not have the meaning the Court of Appeals is subscribing it to. It doesn't mean you act without that intent. It just means we don't have to prove any particular intent at trial. For felonious assault, we prove an assault and a dangerous weapon. For assault, aggravated DV, we prove the assault, the domestic relationship, and serious injury. Those are our proofs at trial. And we proved those elements at trial. There was no irreconcilable verdict here. So unless the court has any other questions, I would forfeit the rest of my time.
Thank you, counsel.
Okay,
The
thank
case
you.
will be submitted.